Hi, I'm Shaye Larkin and thank you for visiting. If you've watched my other videos, you know that I'm a bankruptcy attorney here in San Francisco, and for more than 20 years now I've been helping my clients file Chapter 7 and Chapter 13 bankruptcy cases. In this video, I'm going to talk about objections to the Chapter 13 plan. I recommend you watch my video about the difference between Chapter 7 and Chapter 13 bankruptcy before watching this video. In every Chapter 13 bankruptcy that's filed, there is a Chapter 13 plan. This is the debtor's proposal of what is going to be paid through the plan, to whom, how much, and for how long. The Chapter 13 plan must be approved by the bankruptcy trustee and all creditors, but this happens by default if there are no objections filed. The process of approving the Chapter 13 plan is called confirmation. That's the judge's stamp of approval for the plan. That's what you hope for when you file a Chapter 13. Experienced bankruptcy attorneys are usually able to get their plans confirmed fairly quickly, but bankruptcy law is in a state of flux, and problems can arise in any case. Here are some reasons why an objection might be filed to a Chapter 13 plan. Number 1, the plan is not feasible. This means the debtor's income is not enough to support the plan payments that are required. The debtor simply cannot afford the plan. Number 2, the plan has not been filed in good faith. This means the debtor's income is such that they could not possibly afford the plan payments. It's a little different than the plan just not being feasible. It means their income is so low they couldn't have reasonably expected to make those payments that are being proposed. It also could mean that maybe the debtor's income is such that they can actually afford to pay more than what they are proposing to pay. Number 3, the Chapter 13 plan unfairly discriminates against creditors. This means the plan is creating a separate class of creditor so that one creditor can get paid more than all the other creditors of the same class. An example of this would be treating student loans differently than other general unsecured debts. For example, you propose to pay your student loans 100% on the dollar through the plan, but the other general unsecured creditors only get 3 pennies on the dollar. That would be an example of a situation where the other general unsecured creditors or the trustee could object based on the plan unfairly discriminating. But as a practical matter, in many jurisdictions, it's not considered discriminatory to treat student loan debt differently because it's not dischargeable. Number 4, the plan is not in the best interest of creditors. The Chapter 13 plan must treat creditors the same way they would be treated in a Chapter 7 bankruptcy if assets were being distributed to creditors by the Chapter 7 trustee. So, for example, in a Chapter 7, if the Chapter 7 trustee would have sold a non-exempt asset and paid money to the creditors in order of priority, those same creditors must receive the same amount through the Chapter 13 plan if the debtor wants to protect that non-exempt asset. Last example, the Chapter 13 plan contains errors. The trustee or creditors can object if there are errors in the Chapter 13 plan. For example, maybe it's not the most current model plan that the court wants you to use when you file Chapter 13, or maybe there are other errors such as information is listed in the wrong place or omitted from the bankruptcy filing or the Chapter 13 plan. So those are just some examples of reasons why either the trustee or a creditor might object to the Chapter 13 plan. Chapter 13 is extremely complicated. It's really important to have an attorney who can guide you through the process. Most Chapter 13 bankruptcies that are filed by unrepresented persons never make it through the system. Thank you for watching this video. Have a great day.